Hi, this is David Rubin. Thank you for visiting my website. Today what we're going to talk about is sort of a new phenomenon in the state of Maryland. It's called mutual consent divorce. Now I want to be clear and tell you when this video is being made. It's November of 2019, and the reason I say that is because mutual consent just started in Maryland in about 2016, and it's changed every year. Now I don't think it's going to change from this point forward, but it may. But I want you to understand that you need to keep up to date. So mutual consent divorce in Maryland means that people can now get divorced in Maryland while still living in the same home. Formerly, people in Maryland, unless they were fault grounds such as adultery or cruelty or something like that, had to be physically separated, living in different homes for more than 1 year. No longer. Under mutual consent in Maryland, you can live under the same roof, or you can live separate and apart for less than 12 months and still get a divorce, what we call a judgment of absolute divorce, which is another word in Maryland for a final divorce. Every week we get calls from people who want to get divorced but still want to live in the same home for financial reasons, for other reasons, and previously you weren't able to do that, and now you are. So let me explain how to get a mutual consent divorce in Maryland. The number one thing you have to know about mutual consent divorce in Maryland is you must have a written property settlement agreement. Now, what does that mean? It's a written contract. People used to call them separation agreements, property settlement agreements, marital settlement agreements, contracts, divorce agreements. It's all the same thing. It's a writing that puts in on paper what you and your spouse have agreed upon. And there are three things that you must agree upon in this separation agreement that allows you to get a mutual consent divorce. Number one, you have to discuss alimony. Maybe alimony is going to be paid, maybe alimony is not going to be paid. Alimony is another word for spousal support. You have to put in that written agreement whether or not alimony is going to be paid, whether it's going to be waived, and be specific about what that term of alimony or what the conditions of the alimony are going to be. Number two, and this was not in the original mutual consent divorce, but it is now, you have to explain very clearly what property rights are going to be resolved in the separation agreement. In other words, if you have a house, what are you going to do with the house? Is one spouse going to get it? Is the other spouse going to get it? Is it going to be sold? Is there going to be a buyout? 401k, pension plan, bank accounts, personal property, things like that. That has to be resolved. Now, maybe you're in a situation where you don't have any of that, and that's okay. You have to specifically state that you waive that. But if you do have property, your separation agreement has to specifically state what it is that you've agreed upon. Number three, and this is new, when mutual consent first came out, you were not permitted to get mutual consent if you had children. Now you can. As of 2018 and into 19, even some things have changed. If you have children, you can still get mutual consent while you're still living together, which may sound weird, but you're permitted to do that. You have to set forth exactly what the conditions are regarding the kids. What kind of legal custody is there going to be? What kind of physical custody is there going to be? Who are the children going to live with? And what is the child support amount going to be? Very specifically in the law in Maryland, when two people get divorced and they have minor children, you have to designate how much child support there's going to be. In Maryland, we have something called the Maryland Child Support Guidelines. And specifically in this law, it says you must attach a child support guideline worksheet to the marital property settlement agreement when you submit it to the court. And that doesn't necessarily mean that you have to agree upon that child support amount, but you have to submit that to the agreement. So those are the three things that must be in there. If you have a marital settlement agreement that includes alimony, property settlement, and children, you are well on your way to getting a mutual consent divorce. Fourth, you have to file with the court. You have to serve the other party. Neither one of you can claim that the agreement is invalid. And while it used to be that both of you had to attend the divorce hearing, that's no longer the case in Maryland. At this time, only one of you has to attend the divorce hearing. So while many people think, well, mutual consent, I can just file with the court, go up to the court with my spouse, get a divorce the same day. You can't do that yet. It's not that simple. You have to have an agreement in hand. You have to file what we call a complaint for absolute divorce, attach it. If you have children, attach a child support guideline worksheet, get a summons, serve the other person. If that person agrees and doesn't contest it, boom, within 1 or 2 months, you can get a final divorce. If you have any questions about mutual consent divorce, feel free to call me. I'm always available to speak to you, or one of my associates is available to speak to you. You're welcome to email me as well. You're on my website. All my information is there. I look forward to hearing from you. And as always, it's a free consultation to discuss these rights even further.